Well, good evening, everybody. I'm Phil Stasek, past president of the Space Coast Progressive Alliance, and we would like to welcome you tonight to our special event. This is called Supreme Injustice, Ultra-Right Bias on the Bench. We'll be looking at the issues of bias in our local courts, our state courts, our federal courts, the Supreme Court. There has been a lot of discussion lately about perhaps changing the consistency of the Supreme Court. Questions about how justices, how judges are selected. A lot of very, very good questions and important issues that are before our citizenry. The three branches of our government obviously share responsibility with helping our nation to work. And the judicial branch is, of course, critically important. Fair justice for all is something that we all live by. We all dream of in our country. Sometimes we worry about justice for poor people, for people of color. And frankly, that's what we'll be talking about tonight. The question of whether there is, in fact, really an ultra-right bias on the bench, and how that manifests itself, and how we can help our court system to be better. We have four wonderful speakers tonight, four panelists. First, Senator Dwight Bullard. He's the senior political advisor for Florida Rising. He's also a former Florida representative and senator. Then Douglas Keith. He's the counsel for the Brennan Center for Justice. Then Judge A.B. Majid. He's a retired Brevard County Court senior judge, a former state attorney and public defender. And we have Usita Wanavu. Usita is a contributing editor for The New Republic, a former staff writer for The New Yorker and Slate, and he's written several other things that you might be familiar with. We have, again, these four wonderful speakers will be each taking 15 minutes to talk on our panel. Then we will open it up to you, folks that have joined us on Zoom. And for those of you that are joining us via Facebook Live, you'll be able to enter your questions in the chat window, and we'll be able to pass your questions over to our panel. We'll also be asking our panel to make some suggestions, some ideas of an action item, something that you can do rather than us just sitting here talking to each other. We always like to have something, some sort of action that our guests can take. We do like very much to thank you and to have you here tonight, and we encourage you to please spread the word to your friends and family about the fact that the Space Coast Progressive Alliance does these events generally on the first Thursday of every month. We call them First Thursdays for a reason, but obviously because of the holiday, we're working on the second Thursday here in September. I would like to introduce our Space Coast Progressive Alliance President, Rayed Al-Shaibi. And Rayed, I know you've got a few words for our audience.
Oh, thank you, Phil. I just want to welcome everyone for their time, and thank you for the time for joining us to our monthly event at Space Coast Progressive Alliance. We do hold these events on the first Thursday of every month, and very honored to have a great speakers tonight join us on a great subject, timely, perfectly timed. And I want to take this opportunity to thank our Action Project Committee who put this program together. Larry, Abdul, Bonnie, Ida, and Ellen Jones. Great efforts, and thanks to the rest of the APC committee who keep bringing these programs on a monthly basis. But I want to also remind our membership and everyone who joined us today, we would love to get your support. Please join us. It's $25 a year, and it gives us the opportunity to just keep bringing these programs. Also, you can check us out. You can check us and check previous programs on our website. We just updated. It's www.scpaflorida.com. So the event tonight, I look forward to the action plans that we get out of it every month. And I'm looking forward to our speakers and with their action plan. And hopefully we'll be able to adopt some and move on. I think this is why we bring experts, and we're honored to have a great presenters tonight. Just a last reminder, next event will be on October 7th, and it's already been addressed. It's a it's an important subject about human trafficking. So we look forward to seeing you on October 7th of next month. With that, I'll send it back to you, Phil.
Thank you, Ryan. We appreciate that very much, and thank you for your leadership. Again, to those of you that might have just joined us, you're on the Space Coast Progressive Alliance First Thursday event called Supreme Injustice, Ultra-Right Bias on the Bench. Now, our society is very dependent on a good, fair judicial system, one that isn't biased as much as that's humanly possible, one that isn't influenced by political actions as much as that's humanly possible. There have been recently grave concerns, especially in the progressive community, about the apparent shift to the right, to the right wing of our Supreme Court and of federal judges, perhaps local judges, and many people are very concerned about that, and folks are suggesting that we possibly change the way that we select Supreme Court justices, maybe other judges as well. It is fair to ask questions about how serious this is, whether we should be taking action, what kind of action we can take. Our four panelists tonight, Senator Dwight Bullard, Douglas Keith, Judge A.B. Majid, and Osita Wanavu, will be each in turn discussing these issues from their own perspective and from their own viewpoint, from their own personal experience, their own life experience. Then when we're done listening to the panel with its presentation, we open the floor, and those of you that have joined us via Zoom or Facebook Live will all have a chance to join in the discussion, to ask questions, and hopefully we'll have a wonderful, wonderful free-flowing Q&A program after the panelists speak. So without further ado, I would like to hand the floor over to Senator Dwight Bullard, Senior Political Advisor for Florida Rising, a former Florida Representative and Senator. Senator Bullard. I think we still have him.
There we have. Yeah, I was having a little unmute issue there going on, but welcome, I appreciate it.
Welcome.
Thank you, and good evening. Greetings to everyone on the Space Coast. I am Senator Dwight Bullard. As was stated before, I had the honor and privilege of serving in the Florida House and the Florida Senate for 8 years, between the years of 2008 to 2016. And now I am the Senior Political Advisor for Florida Rising, which is the state's largest grassroots independent political organization. We are the merger of two state-based organizations that have been in existence for 10 years each, kind of doing work in their own space. One, Organized Florida, which did a lot of work in the Central Florida area and the I-4 corridor, kind of came out of Acorn, manifested into Organized Now, and then became Organized Florida. And then the legacy organization that I originally was a part of was an organization called New Florida Majority, formerly Florida New Majority, then New Florida Majority. And now we are joined together to become Florida Rising. We do work in approximately 11 counties across the state. And interestingly enough, on our list of expansion counties, as we shift from 11 to 15, is Brevard, because we see a lot of possibility there to make significant change in the Space Coast. So if you see one of our, our bright orange logo somewhere nearby in the future knocking on your door, don't be alarmed. We're just here to save democracy. So,
welcome.
All right. So really kind of want to spend a little time talking about my experience as a state legislature around the probably not as sexy aspect of the right trying to, really kind of undermine the courts, but looking at it from a pipeline standpoint. When we look at the local and the state courts, these are oftentimes the pipeline for federal appointments, Supreme Court judiciary appointments at the latter phases. But much like I'm sure many of you know, Florida has been an incubator for bad ideas for a long time, right? Whether it be Stand Your Ground, whether it's HB1, which thanks to the courts, we got a victory today. And that's hot off the presses that HB1 was, at least portions of it was struck down in the federal, in the courts today. And so we're excited about that. But when we look at kind of the extreme right philosophical shift in the state of Florida that's taken place, throughout the 2000s, actually late 90s into the 2000s, one of the sticking points, especially over the last, I would say 10 to 15 years, has been an attack on the structure, the appointments at our local circuits and our state level courts. When I was in the legislature, we engaged in multiple fights with then the Scott administration, Rick Scott administration, around substantive changes he was trying to make to the way our courts were set up. If folks remember, there was a point where he was trying to shift the number of Supreme Court justices, creating kind of a two-tier Supreme Court system, one for civil cases and one for criminal cases, in which he would have tried to attempt to make significant appointments in both spaces by expansion of the court into these kind of two-tiered systems. That failed. There was another attempt around forcing retirement, on judges that would have granted him the ability to appoint new judges before he left office, as opposed to those judges being the appointment of whomever the new governor was that came in following his administration. So I say this to say that there's been countless attempts on the state level to do exactly what you're kind of seeing happening at the federal level, especially under former President Trump, in terms of this thing. So look no further than your own backyard when those things happen, But I have to take a step back, because we can talk about those fights at kind of like the state legislative level, but let's really talk grassroots for a couple of seconds, right? Part of the challenge that we face here in the state of Florida is that not all states elect their judges at the circuit level. Florida is one of those states that does just that. But there's never really been significant political education for people around what to look for in a judge. Now, the canons of ethics that govern judicial elections and judicial appointments oftentimes talk about these judges not being able to take political positions or talk about how they will weigh in on certain cases. And that is oftentimes disheartening to folks when they try to ask the question about where a judge stands on things like Roe v. Wade or gun control or some of those issues. And those folks running for office are oftentimes saying, well, I can't take an opinion, I can't take a stance on those things. And so for those of us on the progressive left, it becomes a point of frustration, because those are the questions that we become accustomed to asking. And therefore the larger electorate, if they're relying on us for political opinion, oftentimes are left, kind of with a shrug as to, not knowing who the judicial candidates are in a respective circuit. One thing that I would press as a grassroots advocate, as somebody who's trying to educate community on a continuous basis around these judicial elections, is to delve a little bit more into their resume. Not to say that job trajectory necessarily associates with where a potential candidate for office, for the position of judge may fall, but sometimes certain points should stick out. And things like whether or not they are a guardian ad litem, whether or not they work for legal services, whether or not they operate as a public defender, as opposed to what we find, which is a number of folks that have a more prosecutorial mindset when it comes to the judiciary. One of the things that I've been working on within our organization over the last few years is, of course, reform and significant changes around the criminal legal system. And what we find is that you have a disproportionate number of prosecutors that have now become judges. And the thing about a prosecutor or a prosecutor's mindset is not to disparage prosecutors, but the conditions that are created around being a prosecutor are ones that are centered around oftentimes putting people in jail based on the current legal system that we have in place. And so there has to be an acknowledgement by somebody running for that position that the current legal system is biased. Now, we know all the reports, all the statistics, all the different publications have shown us that there is a bias in our system. There is systemic racism, in our criminal legal system. The numbers bear that out. But it's up to us as an electorate to now kind of flush that out when we're thinking about nominees for these positions that we're voting on, in any given year. In most judicial circuits, you're going to have at minimum 2 to 3 vacancies open up. In a case like Miami-Dade, where I reside, you'll oftentimes have, in excess of 10 or 12, judicial races that will be happening, whether it be at the circuit level or the county level. And the makeup and the mindset of those individuals that are running are so critically important. One of the challenges that the 18th Judicial Circuit, where many of you reside, is that although the makeup of that court has shown significant strides in gender diversity, you have an overwhelming number of women judges in the 18th Circuit, you do not have the ethnic diversity that oftentimes are sought. I would argue that you may or may not have had a black woman judge elected in Brevard or Seminole County over the time that the judiciary has been made up. And I say that not as some alarming fact, because the reality is Miami-Dade, in all of its diversity, just elected its first Black female judge just this past cycle, right? So it's not uncommon that there is a kind of baked-in bias in the election of judges, and we have to be better. And I say we, the collective we, have to be better about the makeup and diversity of our judiciary if we're going to continue to elect judges here in the state of Florida as we do. That being said, going back to my time in the legislature, one of the other aspects that has been so troubling and alarming is the blind spots that gubernatorial administrations have had around kind of the two-step process around how judges are appointed here in the state of Florida. There is this little entity that a lot of folks don't appreciate, known as the Judicial Nominating Committee. These are gubernatorial appointees made here in the state of Florida of individuals who oftentimes will pick the pool of judges or pool of judicial candidates that a governor gets to choose from. So there's a lack of diversity that we've argued, and I say we as former president of the State Legislative Black Caucus, we used to argue that you had a bias on the Judicial Nominating Committee because of an absence of diversity in terms of gender, in terms of race, in terms of orientation, all those other things that make diversity so rich. And that, as a result, created a pipeline issue around the pool of nominees that a governor could choose from in appointing a judge, right? And so you would have opportunities and vacancies, which would oftentimes be the only outlet for ethnic diversity because of the unfortunate reality of particular electorates, right? To get someone nominated to the bench. And so we would be pressing, whether it was Charlie Crist, whether it was Rick Scott, and now the pressing of Ron DeSantis around creating a greater pipeline of more ethnically, more culturally, and more, gender orientation, all those things being part of the makeup and the ideology around who you're going to nominate as a judge, right? So why am I bringing this up? Why am I talking about this kind of like minutia of the process? Well, the reality is who we elect to be the governor, and we think about the hundreds of appointments that a gubernatorial administration has everything to do with the roadblocks being eliminated or being created for a more diverse judiciary around ideology, right? Like if we're thinking about the concept of fairness, then we also have to think about the notion that the right does not care about the notion of fairness, right? We oftentimes on the left kind of struggle with this, like everyone should have a seat at the table, but we have to understand the right is very intentional about who they appoint to these positions, about the kind of nominees that they create. One example is someone who was a classmate of mine who's now on the Florida Supreme Court. And I say that because as Supreme Court nominees go, and we know that these are lifetime appointments, even at the state level, even though we go through that kind of, voting to retain or not retain, which oftentimes leads to the retention. It's very rare that you have a Supreme Court justice that's voted out on these retention votes that we have in the state of Florida. So by and large,
2 minutes.
Got it. By and large, these are lifetime appointments. So we have to be very, very critical in the future about how we vote, who we vote for, and ask the essential questions around the judiciary. The reason I bring up my classmates is because, I'm in my 40s, he's in his 40s, and this is now someone who can ultimately impact the judiciary here in the state of Florida for the next 25, 30 years of his life. And that was an intentional effort on the part of the DeSantis administration to create a space for somebody who is now going to be voting on these critical issues moving forward. So again, as you can see, my through line is this: we need a better educated electorate. We need to be more intentional about who we vote for and how we vote. And I'm sure that will be related to my call to action later. So stay tuned.
Thank you very much. Thank you so much. If we were having our normal meeting in a large auditorium, you'd be having a great round of applause. And we thank you so much for taking your time and bringing your message to us. That was Senator Dwight Bullard. He's the senior political advisor for Florida Rising, former Florida representative and senator. And hopefully we'll get to see a lot more of you in our neck of the woods up here in the Space Coast. I would like to remind everybody that has just joined us that you are watching the Space Coast Progressive Alliance first Thursday event called Supreme Injustice, Ultra-Right Bias on the Bench. And we have four wonderful panelists tonight. And when they're done with their presentations, we open the floor for you. Those of you that are on Zoom, you'll be able to join us by raising your hand. There's a little feature on Zoom in the corner of your screen, depending on whether you're on a computer or an iPad or whatever device you're using. Somewhere there will be a little button that says reactions. And when you click that, it'll let you raise your hand. We'll be watching for people to raise their hands so that we can recognize you. The question and answer period follows our last speaker tonight. And if you're on Facebook Live, you can send in a message through the chat, and we'll be reading through the chat, bringing up questions for our panelists. Our next speaker tonight, Douglas Keith. He is a counsel for the Brennan Center for Justice. And Douglas, you have the floor.
Thank you so much. Thank you to the Space Coast Progressive Alliance for having me. It's really exciting that you all are having these regular conversations. My name is Doug Keith. I'm counsel at the Brennan Center for Justice at NYU School of Law, which is a law and policy institute based at the law school. Believe it or not, this is the state court portion of tonight's event, because I also want to talk to you about the unsexy world of state courts and just how important they are and how they play into this, this conservative takeover that you all are talking about. So just to take a step back, and I'll talk about a lot of states, since our our organization really focuses nationally, every state has its own judicial system. Most state courts are courts of what's called general jurisdiction, meaning they can hear pretty much any case, whether it has to do with state law or federal law, US Constitution or state constitution. And as a result, these state courts, they actually hear many more cases than the federal courts do. State courts hear about 95% of all cases filed in the United States every year. And that's everything from, traffic violations up to alleged constitutional violations. But it also means these courts are critically important, and who sits on them is critically important. Beyond these numbers, state Supreme Courts also can be the final word on issues and cases that you might think would come before the US Supreme Court. So just to give a couple examples, partisan gerrymandering, the act of legislators, drawing their maps to help themselves and help their own party, and essentially picking their voters rather than having the voters pick them, to the extent that one party is getting a significant benefit over the other. The US Supreme Court has said recently that they couldn't step in when it comes to partisan gerrymandering. There's nothing they could do, and the problem's just going to exist, and the court has no way to solve it. One thing the court did say in that opinion, though, was they said, state courts might be able to do something. And as it turns out, they're right. The Pennsylvania Supreme Court, around the same time that the US Supreme Court said, we can't do anything here, the Pennsylvania Supreme Court looked at its own laws and said, actually, our law actually prohibits this. A court in North Carolina said the same thing. They said, actually, North Carolina law prohibits this. And they made, in both states, they made legislators redraw the maps. But because these cases were decided by state courts under state law, there was no way to appeal it to the US Supreme Court. Try as they might, the legislators in both states appealed their cases in Pennsylvania to the US Supreme Court, and the US Supreme Court said, we can't get involved here. So these courts ended up being the final word on this critical issue that so many of us are focused on today. Just to give another example, reproductive rights. We are all watching the US Supreme Court for what it is going to do this year to Roe v. Wade. That decision will impact the law in many, many states, but not every state. In Kansas, for example, the Kansas Supreme Court, not a state you would maybe think of as the most progressive in the country. That Supreme Court recently determined that actually the Kansas Constitution protects reproductive choice. Regardless of what the US Supreme Court says about the US Constitution, Kansas law is a right to choose is enshrined in the state's constitution. And again, because this was decided under Kansas law, there's no way to appeal this case to the US Supreme Court. So these courts can just be vitally important. You don't have to look any further back than 2020 to see state Supreme Courts deciding cases related to election rules in the run-up to the election day, to deciding whether a governor's emergency orders related to the pandemic could stand or fall, to see just how important these courts can be. And this is something with the ongoing redistricting cycle and the US Supreme Court becoming even more conservative and more unfriendly to civil rights litigation, we should expect these state courts to become only more important in the coming years. And we should expect more and more high-profile cases to play out there. So nationally, you heard a bit about Florida from Senator Bullard. Nationally, what's the process for getting on these courts? There are a number of different paths to the bench across the country, but by and large, regardless of the system, these systems have resulted in courts that are homogeneous, as Senator Bullard spoke to, and just don't reflect the public they serve. And it's crucial that something change, sort of regardless of the system you're looking at. So just to give you a sense of what happens across the country, 21 states use elections to select their highest judges. 14 of those are nonpartisan, 7 of those are partisan. 29 states use some kind of appointment system like Florida does. Often the appointment by the governor. In a couple of states, the legislature makes the appointments. And sometimes the governor can make the appointment on their own, or sometimes they have to select from a list given to them by one of these judicial nominating commissions or nominating committees, as exists in Florida. Now, that's when a judge steps down at the end of their term. If a judge vacates their seat in the middle of a term, maybe they got appointed to a different position or they just retired. That's what we call an interim appointment. And in those cases, when a seat opens up, the governor can pretty much always make the appointment, no matter what state you're looking in. The only question is whether or not they have to use a list given to them by one of those nominating committees. So as you heard from Senator Bullard, in Florida, the governor appoints from a list of candidates recommended by the nominating commission, and then justices stand in those retention elections for subsequent terms. But Florida is a really good example of how the devil is in the details with these systems. Originally, that nominating commission was made up of members who were appointed by the governor, appointed 3 members. The Florida Bar appointed 3 members. And then the final 3 were actually selected by those 6 coming together and agreeing on 3 other appointees. The problem was for Florida's governors, that wasn't resulting in the names coming to them that they wanted to see. They weren't getting their staunch allies onto the bench. They were just getting these folks who were recommended by this sort of group that had managed to come to agreement on their fellow commissioners. So Governor Jeb Bush and the Republican legislature in 2001 decided to change how that system worked. Now the governor appoints 5 members directly. The bar nominates 4 members to the governor. The governor can actually tell the bar, no, I don't like that list. You need to give me a new list. And then eventually the commission is pretty much just made up of the governor's allies. The Governor DeSantis and Scott in particular have made it so that these nominating committees are really just political patronage entities. It's their allies that sit on these committees and they do the governor's bidding. And then in the rare instance where they don't, as happened to Governor DeSantis recently, he actually pressured a nominating commission chair to leave his post because they didn't recommend the judge that he wanted them to recommend. And then he was replaced by a new commissioner that would make that recommendation. And then these retention elections that we were talking about, they're generally pretty quiet until, as often happens, a conservative group decides that these retention elections are an opportunity to maybe flip the majority on a state's court. Something we saw in Iowa, for example, after Iowa became the 3rd state in the country to recognize marriage equality as a result of a state Supreme Court decision. After that decision, conservative groups from across the country flooded the state with money in an effort to unseat 3 justices, and they succeeded. Florida's seen pretty quiet retention elections, except in 2012 when 3 liberal justices were up for retention, and then millions of dollars poured into the state to try and unseat them. Although they managed to defeat that anti-retention campaign. Elections generally across the country, we've tracked spending in state Supreme Court elections for the last 20 years, and these races, especially since Citizens United, are increasingly dominated by outside interest groups, largely from the right. And in particular, the biggest spender in these state Supreme Court elections tends to be the Judicial Crisis Network, which you may know because they also spend millions to influence who sits on the US Supreme Court. They spent $17 million in just a couple of years in order to, 1, defeat Merrick Garland and ensure he did not reach the US Supreme Court, and to get Justice Neil Gorsuch seated on the Supreme Court. And so that's at the same time, they're spending millions to decide who sits on the US Supreme Court. They're spending smaller sums, but maybe having even more of an impact at the state level. And I should say that manipulation of Florida's system in order to give the one party an advantage over the other, that's not unique to Florida. We are seeing across the country, state legislators are introducing bills in order to change the selection system in their state to give their party an advantage. And the vast majority of these bills are coming from the right other than the left. I won't speak to let me give you some quick numbers about the representation on the bench across the country, just because I think it's so important. I know you heard a bit about Florida, but just generally, my colleagues have been tracking representation on the bench. And state high courts are wildly unrepresentative of the public they're supposed to serve. 22 states currently have no justices who publicly identify as a person of color. This includes 11 states where people of color make up at least 20% of the population. There are no Black justices in 28 states. There are no Latino justices in 40 states. There are no Asian American justices in 44 states. In 12 states, there's only one woman on the state Supreme Court bench. And when you look at professional diversity, I think the point Senator Bullard was making is crucial. 43 states have a former prosecutor on their state Supreme Court. 19 have a former public defender. And there's tons of research showing that this representation matters. Researchers have found that white federal judges placed more conditions on pretrial release than Black federal judges. At the appellate level, studies found that white judges were more likely than Black judges to rule against plaintiffs in Voting Rights Act cases, and more likely to rule for plaintiffs challenging affirmative action programs. One recent study found that prosecutors were more likely to rule against alleged victims in employment discrimination suits than anyone else on the bench. And so it's just to say that the background that people bring to the bench with them is crucial, and research shows that it really does affect decision making. So the 2 points I want you to take from that are one, that these courts are really important, and two, that selection systems are broken.
2 minutes, Doug.
Great. So I want to give a little bit of some action discussion here. I know we're going to talk about it later too. So what do I want you to do with those 2 points? One, as you've been told already, pay attention to these courts. Governors often have free reign to do what they do, not just because the law gives them influence, but because they know people aren't really paying attention to these courts. Courts themselves are also made up of people, and if the public is paying closer attention and there's outcry when they do certain things or when people are appointed, they may be a little bit more timid about taking certain actions. They know they're being watched. You can also demand better appointments and organize around them. Advocates need to, and many are in a number of states, think about how to work within these selection systems to build a stronger bench and get the people on the bench and in the pipeline who they want to be there. And finally, we can advocate for changes to these selection processes, which are deeply broken. In Florida, Assemblymember Driscoll and Senator Thurston have a bill, HB 161, which would bring back the former nominating commission in Florida, which was seen as one of the best in the country. The bar would appoint 3 members without the governor being able to veto. The governor would appoint 3 members. 3 members would be appointed by those other 6. And then the JNC, the nominating committee, was also published demographic data on all of their commissioners. So we knew who's sitting on these important bodies and who's influencing who sits on these courts. So I'm happy to talk more later and really appreciate you having me as part of the discussion.
Thank you so much, Douglas. What a wonderful presentation. And one of the things and again, thank you very much. Believe me, if we were in an auditorium, you'd have a lot of folks giving you a good round of applause. There's a lot of love in this room. One of the things that people might want to know is how can they go look up information from the Brennan Center? What is the website so people could go take a look?
Thank you for asking. So brennancenter.org is our website. And if you want to learn more about how judges are selected in Florida or in any other state, we also have an interactive map you could look at, judicialselectionmap.brennancenter.org. If you go to that link, you'll find a map you can click around, see all different levels of courts in your state and others, and learn more about how those judges reach the bench.
A wonderful and very valuable resource for all of us. Thank you very much. For the average citizen, really the only chance you ever get to see real, actual court activities is when you're called up for jury duty. Our next speaker is famous for that. Our next speaker is Judge A.B. Majid. He's a retired Brevard County senior judge and a former state attorney and public defender. One of the things that the judge, he is much beloved in our Space Coast, and one of the things that he's famous for is briefing his jury pool. When people come in for jury duty, Judge Majid is famous for talking about the importance of the courts, the importance of fairness and the judicial system, and our participation in it, our awareness of it. And honestly, I have been inspired many times by listening to the judge speak in various venues. And so we are very, very lucky tonight to have Judge A.B. Majid. Judge, you have the floor.
Thank you, sir, and congratulations on a wonderful program. And it's very, very kind of you. And I know how hard it is to put on a program like this. My name is Ali B. Majid. I'm originally from the country of Guyana, known as British Guyana in South America. My parents came to Guyana with the British as indentured servants. I came to America in 1969 on a student visa. I'm not the child of immigrant. I am the immigrant. I am the seed. I am tremendously fond of the United States Constitution and what it stands for. Now, I will speak on a somewhat different topic. Maybe I misunderstood my mission today when it says supreme injustice, ultra-right bias on the court. And so I will speak about the United States Supreme Court and whether or not it is really demonstrating through its various opinions an ultra-right-wing bias. So as judges normally do, before I come to a conclusion, I will discuss some cases and some justices. Having spent all my life in the state court system, I'll be fun that if we today discuss some of the United States Supreme Court. It is with a little level of trepidation that I decided to join this into this discussion because I have mine might be a little dissenting opinion. So let's see, you know, we have 9 members of the United States Supreme Court. These folks represent an education level, if you were to group them and aggregate it, probably the highest and loftiest education level as a group anywhere in the world. They are graduates of the best universities. Some of them are summa cum laude graduates. They also are chock full of experience, having served as clerks of the highest courts and worked their way through the system. 3 of them were clerks of 3 former Supreme Court justices. So they've been involved in the Supreme Court for a while. And so these are not folks who are just political hacks. These are professional folks of the highest level. So now let's look at some recent cases. I'm going to look at 3 particular cases. I'm going to look at the ACA, the Affordable Care Act. Now, what was the opinion in that case? That case was actually written by Justice Roberts. It's called the National Federation of Independent Businesses versus Sebelius, who was the secretary. Justice Roberts found that in part it was constitutional and in other part it was unconstitutional. It was a 5-4 ruling. But they didn't want to talk about universal health care or health care for the poor, etc. It came into a very complex procedural issue. And that is whether the whether this individual mandate was in fact a penalty, was it a tax, what was it? And the court held per Justice Roberts, listen, this is a tax. One, it may be reasonably enacted by Congress. They found that they characterized this as a tax, and it says the Constitution permits such a tax, and it is not the role of the court. And here's where they go. Not only was it the power of Congress, but they want to limit the role of the court rather than expand the role of the court. And Justice Roberts said it was not the role of the court to decide whether this tax, the wisdom of this tax or the fairness of this tax. And so this case was ruled strictly as a taxing purpose of Congress. Let's go to the DACA. Now, this case here, once again, was a 5-4 ruling, one of the conservative justices moving over to where we call the liberal justice. And from my point of view, from being a judge for 26 years, I really don't like to label conservative justice or liberal justice. Because just as Justice Roberts said, we don't have Obama justices, Trump justices, Bush justices. Anyway, here's what we did with the DACA. Was it the opinion of the DACA? This was something by the Department of Homeland Security. They said there were 2 basic issues to be considered. whether to retain what they call forbearance from removal of immigrants from United States of America, and the hardship caused by this rescission and the consequences to employers. And here's what the court concluded. One, the Division of Homeland Security had an absolute right to remove these folks. That's an unusual statement when you consider the ruling. But before they removed these folks, the citizens, and before they discounted that these citizens were not here lawfully, they must make two considerations. One, did the agency appreciate the scope of its discretion, and did it exercise its discretion in a reasonable manner? And the court concluded, no, it did not exercise its discretion in a reasonable manner. In fact, it exercises discretion in an arbitrary manner. And what did it decide? That DACA was constitutional or not? No, that was not the decision at all. They remanded the case back to Homeland Security and said, hey, consider these two things before you make your decision. You cannot make arbitrary decisions. So once again, we see that cases are decided on very, very complex issues, whereas the public gets involved in the emotional issues. The justices do not. They discuss cases as closely as possible as to whether or not they're constitutional. How about Senate Bill number 8? What is that? What is Senate Bill number 8? Well, that is actually the title of the Texas 6 weeks law. What did the court decide? Justice Roberts was one of the four that dissented in this opinion. But this case did not fall on whether or not abortion was legal, illegal, should we reverse Roe v. Wade, etc. This was actually a one-paragraph opinion. And all it said was, listen, we do not see enough here to enter an emergency relief in this case. The constitutionality of the law is not what's before us. The dissenting justices said 10,000 bounty, that's what we need to consider. The state has passed a statute and they leave it to the citizens to enforce the statute. But the Supreme Court, in my view, thought that abortion was such a divisive issue. It's such a significant issue in this nation. I don't think there's any issue that's more divisive than abortion. And it's probably wants to follow the normal procedure it follows. First, we go to the district court, then we go to the district court of appeals, then the matter is briefed and properly presented to the Supreme Court before it rules. Was it overruling Roe v. Wade? No. Listen, from the time Roe v. Wade was passed, I think it was 1978 to now, we have progressed tremendously in terms of technology, in terms of science, etc. And it's my view that the Supreme Court wants a fully briefed presentation on the change of technology and science-based facts to make a full decision on Roe v. Wade. And so it's waiting for a better time and a better opportunity when it can fully consider the issues. Now, those are three cases. How about if we discuss some justices? Well, Justice Gorsuch has moved over and joined the liberals to reach a 5-4 decision. Justice Roberts has done that repeatedly, etc. And so to say that the court is leaning to the right more than ever, you really have a 6-3 if you were to say liberal and conservative, 6 conservatives and 3 liberals. Yet we have so many 5-4 opinions. You know, the majority of Supreme Court opinions are actually unanimous. There are very few opinions, when you look at them statistically, that are not unanimous opinions. 5-4 comes next. Then you actually have some 6-3 opinions, etc. But the majority of opinions are unanimous. Now, we live in a time when in America, everything is subject to attack. We attack the press as being unfair. We attack the electoral process as being unfair. We attack television, stage, the media as being unfair. We have a label for everything. And it's my opinion that the Supreme Court is not right or left. They have very complex issues to decide, complex analysis to make before they come to a ruling. And by the by, Their ruling is approved by the majority of this nation. Let's go back to the history and see the progress we've made. There was a time when this Supreme Court ruled, the United States Supreme Court ruled, that a black man is not a human being. A black man is just like a horse or a spade that you can trade and sell like anything else. Yet, very recently, we had a black man elected not once, but twice as president of the United States. And here we had a very prominent white person who's supposed to be arch conservative, couldn't make it to the second round. So here's something else. When you look at the case of Plessy v. Ferguson, when you look at how long ago was it that a black man could not marry a white person, a white female, or a white female could not marry a black person. Today on the United States Supreme Court, one of the most conservative person is Clarence Thomas. His wife is white. There was a time when we could not sit here as a group. A black person could not stay at the Hilton Hotel. A black person could not stay at the Ritz-Carlton. Now, look at the corporate progress blacks have made, minorities have made. I myself ran for election in Brevard County, a place where no minorities were ever elected. I was the first minority person of color to be elected. I remained on the bench for 24 years and served 2 years as a senior judge. I was challenged, and when I was challenged by 2 white candidates in a very conservative community, you plan your election, and I won not at the general election, but I defeated both of them at the primary election. And so, are the courts leaning right? Are the courts leaning left? No, courts do not consider political factors when they make a ruling. Right here in Florida, we have a very, very bold and brave judge Judge Gore from Pinellas County, who decided the Shivo case. He was going to a church for 24 years. He was excommunicated from his church. People in Washington, D.C., congressmen and senators, governors, were telling him what the opinion should be, what the ruling should be. Yet he ruled according to the facts and the law. But history does tell us about a judge who did not rule according to the facts and the law, who was swayed by the public clamor. And we all know the name of that judge. His name was Pontius Pilate. And he made a ruling, and he said, I wash my hands of it. But we don't do that. The United States Supreme Court doesn't wash their hands of it. They get in the middle of it. Same thing with the judges in the state of Florida. Now, we want to make some changes. You want to hear about some action plan. They say all politics is local. Let's deal with Brevard County. If you really want to make changes in Brevard County, here's what you need to do. You can make a magnificent and powerful change tomorrow within 24 hours. Every Democrat should go down to the supervisor of election and register as Republicans. What a crazy thing, isn't it? Well, here's what happened. You have no say in who's the state attorney because he's elected at the Republican primary. You have no say who's the sheriff. You have no say who's the public defender. You have no say who's the supervisor of elections. No say in who's the clerk of court. No say who's the property appraiser, because all these are decided at the primary election. You have no say at all in what happens in Brevard County. You want to make a change, go down to the supervisor of election and register as a Republican so you can vote in the primary. If you cannot vote in the primary, you have no say at all.
2 minutes.
Now, I will conclude with this. You ask anyone anywhere in the world, if they get into trouble, which country they want to be tried in, and you will find without an exception, they want to be tried in the United States of America. I was a judge for 26 years, and I could not think of a single judge whose integrity, whose credibility was impaired through improper conduct. And the United States Supreme Court is a shining example to the world. If any one of these justices were to leave the United States Supreme Court, they will make 10 times, 20 times earn more than they're earning right now. These are people of the highest caliber, highest intellectual caliber, highest integrity. And maybe we ought not to be so hasty in putting a label on them, like we do with our electoral process, like we do with our press, like we do with our politicians. Even our preachers now are getting a label. So my conclusion is this. We are very privileged, each and every one of us are very privileged to live in a country that's governed by the rule of law. America's greatness and America's future lies not in our armaments. It lies in our courts of law. We are a nation governed by the rule of law. And as long as we have the people that we have as judges, we will always be a great nation. We will be an enviable nation. Now, let me close with this one thought. We talk about, when we get to the Senate confirmation, we talk about all these judges, but as they get older, they change. Many judges, we all get older, we change. I used to play sports. And when I was younger, I was a home run hitter. Now, man, I am lucky if I can get it out of the infield. I'm a bunter as opposed to a home run hitter. And so we all become conservative as time goes on. We get our families, etc. Now, finally, I want to say this. Every day when we wake up, we are very, very privileged to have people who have spoken here today with diverging opinion. But the time has come in our society where we place labels on people quickly. We cannot have a civil discourse. And to say that our courts of law are right or left does an injustice to our court. That's my take on it. I've given you the case law. I've given you a number of justices. We had justices who were appointed by President Reagan, went on the side of the liberals when they made ruling. In Roe v. Wade, I think it was Justice Powell, conservative justice, helped write the opinion of Roe v. Wade. And so time and again, we've seen that the pendulum has moved from conservative to liberals. But here's a thought that people might not like to hear. If you do an analysis, you'll find that the quote unquote liberal justices rarely ever go over to the conservative side. Very rarely. And for a 5-4 decision or a 6-3 decision. Those would be my concluding statement. I am of the firm belief, coming here as an immigrant, working in the judicial process, that we have the best judicial process in the world. We have faults. We're not perfect. But you ask anyone in the world where they wish to be tried. Our opinions are the envy of the world. Our justices write remarkably articulate and good findings that's unmatched anywhere in the world. Their grammar, their diction, their articulation is beyond compare. With that, I would conclude with this.
Thank you, Judge. We really appreciate it. Judge A.B. Majid, everybody would be giving you a standing ovation right now. The emotion, the commitment to our Constitution and to your profession radiates from you, sir. You really are well spoken. For those of you that have just joined us, this is the Space Coast Progressive Alliance First Thursday event called Supreme Injustice, Ultra-Right Bias on the Bench. As we look at the issues of fairness in our judicial system, we have 4 wonderful speakers, and Judge Majid was just the third. After we get our last speaker in, we're going to open the floor for a Q&A. Those of you that are with us on Zoom, I ask you to take a look around on your platform, whatever it is you're using, a phone or iPad or your computer, and look for a little thing that says reactions. When you find that, you'll see that you can raise your hand, and after our 4th speaker, we'll open the floor and we'll encourage you to ask questions of our panel. I'm going to be encouraging our panel to actually talk to each other. I think that it's very interesting when we have our panelists questioning each other and supporting each other, expanding on each other's viewpoints. I think it's excellent. And if you are joining us on Facebook Live, you can just use the chat to send a question, and we'll be watching for those questions to appear. So again, thank you again, Judge Majid. Our next speaker is Usita Wanavu, and Usita is a contributing editor at the New Republic, a former staff writer for the New Yorker and Slate. And he has a tremendous experience at writing and examining and expressing interesting opinions on these topics. And so I'm going to hand the floor right over to Usita.
Well, thank you for having me. Very grateful to the Space Coast Progressive Alliance for the invitation. It's been a wonderful event so far. Very flattered by Phil saying that I have a tremendous experience in writing. I'm actually quite young and I've only been, writing professionally about these issues for a little bit of time. But I'm grateful that I got the invitation. Anyway, I don't know that I'll take up the full 15 minutes just because, I've tended to go long on these kinds of things. So I made a real effort to constrain my remarks here tonight. But I think it would be worth starting with a few words on Judge Mahid's powerful speech. Great admiration for anybody who's spent as long as he has in the legal system as a defender of justice, as a defender of legal principles. I will say that I am one of the people who I think Judge Mahid would probably characterize as an attacker, one of the people who sort of ascribes labels to different things, a partisan, a left-wing person. And I do that not because I am trying to undermine the American spirit or undermine legal order or to make people hate each other. I just see as a political analyst certain things about American society today that I find quite troubling. And I think a lot of those debates obviously are located within our judiciary, within our federal judicial system. We all have this image that we're taught coming up in school of the court as this sort of impartial mediator of policy disputes, as an impartial analyst, or a place where impartial analysts of the Constitution go to sort of tell the American people what to think about whether this or that law is in accordance with the Constitution based on a pure, down-the-line, apolitical reading. We're told that justices are appointed for that reason. I don't think that's true. If it were the case that the Supreme Court were not a partisan institution, where everybody just sort of went to do their best to analyze the Constitution from an impartial perspective, it would be very hard to explain why Republicans under Obama refused to grant a hearing to Merrick Garland, who Obama had appointed to a Supreme Court seat. If it were the case that this was an apolitical institution, why would they have done that? Merrick Garland is an experienced legal mind, who's been working in the federal system for a long time. He's a smart guy. Why did that happen? I don't think Republicans were stupid. I think that they understood that the Supreme Court, whatever we're taught about it in civics class, plays a substantive role in adjudicating policy disputes for one side or another. Judge Mahid is right in saying that most of the Supreme Court's decisions are not politically controversial. Most of what the Supreme Court does is actually quite technical. It doesn't get a lot of media attention. A lot of cases that would bore everybody to tears if they actually sat through and read the decisions. But it's precisely those rare cases where the Supreme Court does get a lot of attention, where they do make media-grabbing decisions. Those are the cases that often matter the most because they're speaking to some underlying political or ideological dispute that hasn't been resolved anywhere else, that we're looking to the court to provide us a clear answer on. And that's why it's becoming such a contested space. That's why you saw Republicans do what they did under Obama. That's why you have people like myself now arguing that the Democratic Party, progressives, should take an interest in rebalancing the court. But I think in my initial remarks, I was going to spend, I think, a good bit of time talking about not just the current situation, but what the court is actually supposed to do as an institution. Why we have a court, why was it created by the framers, and the extent to which we can envision a more progressive vision for the Supreme Court. I think it's important for progressives to recognize that the Supreme Court, for most of its history, has not actually been an especially progressive institution. We think fondly about decisions like the Brown decision or Bergefell not too long ago, the gay marriage decision, as great moments where the Supreme Court stood up for rights that had been in question. And I think that just because some of those decisions are so recent, we tend to think that that is what the Supreme Court has always kind of done. But for most of the Supreme Court's history, it's actually been quite reactionary. Judge Mahid talked about the Dred Scott decision, a very infamous, very terrible decision they made, denying humanity of African Americans. Legal scholars talk a lot about the Lochner era in the early 20th century when the Supreme Court handed down a lot of decisions aimed at frustrating progressive legislation that would curb the power of big business. That's what the Supreme Court is doing for most of its history up until very recently. And there's a reason for that. I mean, the founders and the framers came to that convention in Philadelphia for very specific kind of reasons. There was a real apprehension amongst the leading statesmen of the day about what state legislatures had been getting up to after the revolution. You had a lot of state legislators looking at public angst about the state of the economy. People were pressing for debt relief and tax relief and paper currency, all things that people like Madison saw as threats to the stability of private property. And they came to the convention in Philadelphia saying, you know what, we can't have this. We can't have a federal government that is actually enthralled to whatever the state legislatures decide. You have to have a sovereign federal government that's capable of quashing a lot of that action, channeling public sentiment through a lot of different channels that'll diffuse energy, create all of these sort of checks in the system to make it difficult for people to sort of rule by popular majorities. And the federal judiciary and the Supreme Court were a large part of that, establishing a sovereign system of federal courts that would override or be considered a top of whatever happened down at the state level. And so when the Supreme Court makes decisions that we view as anti-democratic, when the Supreme Court in the 6-3 majority now, makes decisions like the decision we saw last week not to intervene in SB 8, very unpopular. If it had been put up to the public, it would have been a very unpopular thing for the Supreme Court to have done. When it does that and it acts anti-democratically, on the one hand, we can say that that is a consequence of this particular political situation. Conservatives controlling the court now. But also, those conservatives on the court are doing what the court has always sort of done, and all the court was kind of designed to do. It was designed to be an institution that protected a certain class of Americans at the expense of others. And so that's kind of where I've been at in understanding why the court is doing the things it's doing now. Yes, we're here at this particular majority as a consequence of political events, but also if we want to really change things and create a more progressive judiciary, we have to think, I think, a little bit more ambitiously about why we got here and what it would take to actually create reforms that would make the court a better, more reliable guardian of ordinary people's rights and a more progressive institution. So that's a very wide-ranging discussion that a lot of legal scholars have been having for the past couple of years. I really don't have time to delve into like all of the different solutions that have been proposed, but there are a couple of different major ones I think are worth talking about. One idea that people have been talking about a lot is creating term limits for court membership. Basically now, obviously, you have justices that are there for life. People have proposed reducing that to a term of about 18 years. That's something that would make the court a little less insulated from public opinion, public will, that would provide more of a rotation, move us away from this medieval system where we're always asking to see if how is this justice doing in terms of their health? Are they going to get cancer? How long can they stay alive or hook to an IV so we can keep this seat? That's a terrible way of making decisions. That's a terrible system for keeping people's right. Like it's just medieval that we have that kind of a system in place now in the 21st century. And term limits is one of the more obvious solutions that people have proposed for that particular problem. That's something that can be done. I think most people agree by simple legislation. There's some people who argue it might take constitutional amendment. That might be possible, but there are a lot of people who say that that's something that Congress can pass a law to do. Another idea people have put forward is jurisdiction stripping. Basically, Article 3 of the Constitution says that Congress has some authority to limit, to decide what kinds of cases the Supreme Court can actually take up. John Roberts actually wrote a series of memos about this in the 80s when he was back, in his early days as a conservative legal mind. So conceivably, Democrats in Congress could pass a law saying that, well, the Supreme Court can actually make decisions on voting rights that contradict what Congress has said. It can say that the Supreme Court isn't going to make decisions about climate policy. It's just too important for it to be left to an unelected majority on the court. That's another idea people have put forward. But the idea that people have talked the most about in recent years is actually restructuring the court itself. So on the one hand, you'd have people talk about creating a rotation of justices through the appellate court system, coming up to the Supreme Court to handle cases for a term, then get rotated out. That's one idea. People have talked about creating a kind of nonpartisan ballast where you're adding justices to the court, but Republicans will add some, Democrats will add some. At the end of the day, you're going to get a court that is partisan neutral. And then you have people who say that Democrats in control of Congress now should just pass a law adding justices to the Supreme Court, who we know are going to be Democrats and make liberal-ish decisions. So that's I think that the main set of proposals that get talked about the most. There are other things that people have been discussing for some time now. I should talk to you about a couple of pieces of legislation that are actually in Congress right now. So one is HR 4. That's the John Lewis, I think, Voting Rights Advancement Act is the full name of it. And that's a piece of legislation aimed at counteracting the Shelby decision back in 2013 and also the more recent Brnovich decision, which combined have really facilitated a lot of the attacks on voting rights we've seen across the South and Republican-controlled states. This is a bill that would restore voting rights pre-clearance. Basically, under the Voting Rights Act originally, before Shelby in 2013, states with a history of voting rights discrimination had to pre-clear their voting laws with the federal government to make sure that they weren't going to enact more discriminatory voting laws. Shelby decision basically junked that in 2013. Brnovich decision just recently basically put the final nail in that coffin. And so now the actual federal voting rights framework is very, very vulnerable. The HR 4 basically counteracts that by restoring preclearance and also basically creating a standard where the court will have to take the extent to which a law restricts voting rights as its kind of orienting perspective relative to, the state's own authority in establishing its voting rights laws. Basically, it says that unless you can provide evidence that this is not unduly limiting of voting rights, this or that voting rights law can't stand. That's sort of the simple rendering of what it does. And then the other piece of legislation that we have in this Congress right now is the Judiciary Act. That is a court packing bill. Basically, it says that Biden will have the power to appoint 4 new justices. Democrats control Congress. That will functionally mean the Democrats will add 4 new justices to the Supreme Court. So those are 2 immediate pieces of legislation that are on the table now. Neither of them has any chance of passing as long as the filibuster remains in place. That's a whole nother conversation we could have a whole nother evening about. But that just goes to show, I think, the extent to which Democrats in Congress are beginning to think more seriously about the challenges the court poses to the progressive policy agenda and the threat that it poses to the protection of certain rights. We already saw that with SB 8. We've seen it with voting rights. We don't know where the court's going to go next. But I think that there is real reason for concern for people who have, an egalitarian progressive perspective on, American politics, the extent to which everybody has rights. The court is offered real reason for people to be a little bit apprehensive about where it's going. So as far as the solutions that I personally would endorse, I think the jurisdiction stripping is an interesting idea. The wrinkle there is that the court will ultimately have the power to decide whether or not jurisdiction stripping is constitutional for any given measure. So it's really a way of just throwing, the court will decide whether or not the court is going to be changed in this way, in a kind of weird circular way. I don't think that's a real solution. I think that court packing has been criticized on sort of reasonable grounds. It would create this situation where if Democrats added justices to a court, when they have Congress, that allows Republicans to do the same when they take control of Congress. So you have this back and forth in terms of, well, who actually controls the court? The court basically becomes a representative body. And it could spiral and go that way for a while. That's not an ideal solution. It's not a real legal solution. But I think that first of all, the immediate challenges that we're facing in this country on a policy level, whether you're talking about protecting reproductive rights, enacting climate policy, protecting democracy, as it's being assaulted across half the country, in the South. Those are problems that require immediate solutions that the court, as currently composed, is not going to provide to us. And they're urgent problems. I mean, whether or not African Americans can vote in Texas or Georgia, that is an existential question, and not something that can be punted to the side as like, well, we'll never Democrats take control of the court again. 25 years from now, we'll handle it. That's something that needs to be dealt with now if we're going to really be able to call ourselves democracy for very rich Mulher. Climate change, we have a lot of reason to believe that this is a court that would strike down aggressive regulation. You can read parts of the Sebelius decision that incline you to believe that the federal government's power to enact far-reaching, very sort of strong climate legislation is going to be limited. So these are not problems that you can sort of afford to leave to an unelected court majority, an unelected conservative court majority. So that's one thing that inclines me towards an immediate solution.
2 minutes.
But the other thing is too that you can talk about a less partisan set of solutions and doing a more thoroughgoing reform of the federal judiciary. I think that's long term where we'll have to go. But the prospects for that in our current political environment are not very high. I think it is very well within the realm of plausibility that the American Constitution will never be amended again. I mean, you need 2/3 majority in each House of Congress. You need 38 states to approve whatever amendment gets passed by Congress. That's not something that is possible within the current political landscape, and it's not going to be possible for the foreseeable future. And so the number of actual reforms that are on the table, I think, is fairly constrained. And so that inclines me to sort of think that the Biden administration should just sort of do what it can right now to level things out and sort of begin a conversation about what we'd want an ideal judiciary to look like in the distant future. It should be said, too, that Republicans, I mean, in at least 10 states over the last decade, Republicans have changed the size of their court. Our Supreme Court's size has been changed 7 times. It started out with 6 at its outset. We now have 9. So that's not an unprecedented move. Most of those changes were made as a consequence of immediate political considerations that, in keeping with then current political and policy debates. So the idea that Democrats would do the same now is not, it's not out of step with American history. So I won't take up too much more time, but I will say that I think that people at this point, especially now, given all we've seen happen over the last 10 years, given what Republicans did under Obama to the Garland nomination, given efforts by McConnell, they did everything in their power to make sure that the other parts of the federal judiciary are going to be staffed by conservative justices. The courts are political institutions. I mean, there's just no avoiding that. They come to their decisions at the Supreme Court on the basis of particular interpretations of American history, American constitutional law. And those are ideological differences between the justices. And so while it's all well and good to sort of believe and tell ourselves that this is still a neutral institution, I think that there should be real alarm, concern from people of a progressive mindset about where the court is actually taking this. And if we really want to preserve equal rights for everybody in this country, I think it means taking seriously the need for real deep reform, both in the immediate sense when it comes to something like court packing, but also in terms of a longer term rethinking of the way the federal judiciary should work.
Usita Wanavu, contributing editor for the New Republic. Thank you very much, Usita. I'll tell you what, I really, really do appreciate your thoughtful approach to this. I know we have several people that are starting to raise their hands, and we're going to be taking that for a second. I would like to take a moment of personal privilege, a point of personal privilege for what it's worth. On our Zoom event, we had I think he might have just dropped off, but we had a former member of our SCPA board who I would like to recognize, and that is Bill Fisk. Bill, I don't know whether you're still with us or not. I don't see you up there. I think he just dropped off. Bill served as a FEMA coroner at Ground Zero on September 11th or following September 11th, the attacks. We know that we're going to be marking the 20th anniversary of that horrific period and recognizing the true heroes that gave so much. Bill has faced health problems that are serious and has made a huge personal sacrifice for us as he served our nation on September 11th. And I just wanted to take a moment to recognize Bill. And Bill, I guess you're not with us anymore. Again, for all of you that have served our nation in so many ways. When we look back at how our nation was brought together by the horrific actions of September 11th, it is in some ways a time that reminds us that we as a nation can stand together in times of great trial. And anyway, my thanks to Bill Fisk, former board member, FEMA coroner. Thank you, Bill, even if you're not here with us tonight. Our first question is coming from Larry Abdullah. Larry, I see you there with your hands up. If you can remove your mute and come live, you've got a question, please remember to keep that to 3 minutes or so, and make sure we have plenty of time for other people to ask questions. Larry, can you
hear me?
We've got you.
Okay, my major concern is election rights and elections. And, you may or may not agree with me, but I think one of our parties and the former president are doing a lot to violate both election rights and elections. And so I wanted to talk about first the two worst decisions I think the Supreme Court has made in my lifetime. One was gutting the Voting Rights Act, and the other was Bush v. Gore with no recount in Florida. Okay, so now getting to those 38 new laws that have passed through legislatures and been signed into law. Many of them, they make it a little harder to vote. You could say, well, we didn't have that before. But many of them also have provisions where the state legislature can actually start the election, can decide the election, and where election officials are being intimidated. And so we have H.R. 1 and H.R. 4. And to be honest with you, I don't know how the three Trump justices will pass on H.R. 1 or H.R. 4. They could surprise me. They did not support Trump's initiatives, but they were so obviously idiotic. But as far as H.R. 1 or H.R. 4, they may decide in terms of state rights. But getting back, I do believe that our republic is in jeopardy. And I want to know from all the panelists how they think some of these issues of voting rights, of elections and voting rights will be decided both in the Supreme Court and in state courts, because I think both have a part to play.
Who of our panelists would like to take the first bite at that question? By the way, I noticed that Douglas, Keith, and see that you have your microphones muted. You can unmute yourself. Who would like to take the first bite at answering Larry's question?
Take a stab.
Go ahead, Senator Bullard, you've got the floor.
Thank you. Just very quickly, kind of going to the makeup of the lower courts. I think, one of the more nefarious things that former President Trump, Leader McConnell did in kind of fast tracking a number of federal appointments at the lower courts was very intentional around stacking those lower courts in preparation for these kinds of battles. That being said, state legislatures across the country are very, they're not savvy by any stretch at the policies that they're passing. There was a legislator that I served with who actually was from Seminole County, interestingly enough, who once said that the state legislature does not need to pass constitutional laws. His word, right? Like that was his goal, right? And so when you're thinking about the notion of constitutionality and the viewpoint of these judges, to kind of think about what Judge Majid pointed out, if they're looking at the constitutionality of these laws, the reason why many of these laws get struck down is because of the lack of savvy, the lack of desire to be on par with the Constitution by many of the laws that are being passed. I mean, when you looked at North Carolina's law that was struck down by the courts, that the ruling was that, you know, they they were precise in their restriction of the Black vote, is what one of the judges, you know, I'm paraphrasing, but that's what one of the judges says, right? Like they were very, very intentional in their bias, in their racism, in their everything that they're trying to do. And so I think that is ultimately going to be one of the saving graces, is that a lot of, you know, the 389 laws that were filed this year across the country that had to do with voter suppression, many of those did not, luckily enough, knock on wood, did not make it through the process. But those that did end up, you know, in these courts and end up as a result being struck down, because you're dealing with folks who are callous, who are rigid, who are very intentional in their pursuit of injustice. And so the courts have no choice in many cases but to say, this is garbage and it's got to go.
And one of the things that's interesting is that many legislatures are sharing language. In other words, somebody will write the language for them, and then it suddenly appears in 5 states with like the exact same verbiage, which is transparently. Anyway, would either of the 3 of the rest of you on the panel like to take a crack at that question that Larry asked? Okay, well, Larry, hopefully that was adequate for you. I see that we have a question from Pam Dershka. Pam wrote a question in our chat, but she may want to ask it live. Pam, would you like to ask your question live, or do you want me to just read from the chat?
I'd be glad to ask. First of all, I have to say, as somebody who has worked really hard to get voters registered, I would respectfully ask you to register as a Democrat. And if we want to make a change, let's get out and get NPAs to be let's work on the Republicans and try and get them to change to be either NPAs or, even better yet, Democrats. That would be my hope.
NPA meaning no party affiliation or independence.
Exactly. And then I wanted to say, at election time, often those of us that are involved in encouraging people to get out to vote, really the question that we're asked more than any other question is about judges. And it is really hard to find good resources that will help us determine the positions of the different judges for retention. And I looked on the site, the Brennan site, and I saw it was really great, showing how many women are on all the different levels in each state and in Florida. And I did put that in the chat. Is there any additional sites that you would point us to for policy decisions? You know, what cases that the judges that were deciding about, how they ruled on certain key cases and things like that? I would ask that from Douglas and any of the others that would like to answer that as well.
It's a terrific question. Douglas, would you like to take that first?
Sure. It is a really great question. Unfortunately, I don't have a great answer for it. There is, as you say, not enough attention on these courts. And in particular in this moment, when the U.S. Supreme Court is, and I will say, is so conservative, there's just a lot of good that can maybe be done at the state level, but that's going to require folks to be paying closer attention to those courts. There are different organizations across the country that in some states are more active than others about evaluating judicial decisions and judicial candidates. The League of Women Voters is one in particular that comes to mind, as in some states publishing voter guides on judges specifically. But really, it is a state-to-state question. Some states do a better job than others, and I'm just not sure about Florida, but I'm sure Senator Bullard might have some more thoughts on that than I do.
And so it just popped up in our chat. Somebody was suggesting the SCOTUS blog. Any thoughts on that?
So that's going to deal only with decisions from the United States Supreme Court rather than state court decisions. So that won't tell you too much when it comes to deciding these elections.
How about our other three panelists? Would you like to weigh in on this and how to help the rank and file? Yes.
Can I comment on Pam's question?
Please.
True. Whenever we have elections, questions about judges are very predominant questions. But, you know, the issue that we're discussing, are we talking about judges or a court that's fair and impartial, or courts that are more attuned to our views of things? If you ask a judge, well, what's your position on gun control? What's your position on the death penalty? What's your position on abortion? Such a question reflects a misunderstanding of what the judge does. Because a judge comes to the end result, to the conclusion, only after the judge has heard all the evidence presented by both sides after direct and cross-examination. And so for you to ask me what's my opinion or what's my position on such an issue is for you to want a judge to have a position without having listened to the evidence, without subjecting the evidence to direct and cross-examination. So the judge comes in with a conclusion even before the case is heard. Who wants such a judge? And so at election time, to ask a judge, what's your position on this issue and what's your position on that issue? I have no position on the issue until I've heard all the facts presented to me. And that's not a complex answer. It's unfair to expect a judge. Nobody wants a judge with a predetermined issue to come to. You don't want to go to Judge Majid, who already has a position on abortion or already has a position on gun control or voting rights. You don't want such a judge. But let me make another point for my friend Dwight has emphasized. When you go to the legislature, the House of Representatives in Florida or the Senate, the way it operates is really the Speaker of the House or the President of the Senate. These are the people who really get bills through. You can put all the bill you want. If the Speaker doesn't want the bill to come through and become a law, it's not going to happen. And if the President of the Senate doesn't want it to move forward, it's not going to happen. So where do we really take away people's voting rights? Listen, in every state of this nation, every time a person is convicted of a felony, you take away their voting rights. Every time a person is convicted of a felony, you take away their driver's license. You take away their ability to go to work. And every time we give them a fine that they can't pay, we redistribute wealth. So we put them in an economic status where they can never attain upward mobility. So the power, you're right, Dwight, you're right, Doug, it's in the state courts. That's where the power and the most harm is done and where the most justice is rendered.
Usidi, would you like to weigh in? Oh, Doug, Dwight.
Yeah, I'll definitely agree that a lot of damage is done at the state level, so you do have to pay attention. I would say that to that point, and I think to the activism that you're pursuing, Pam, one of the things that we can do that is slightly incorrect from the judge's viewpoint is that certain states do make allowances for a number of expansion of democracy policies. Like you have states that allow people to vote in prison. You have states that allow people to vote in jail. You have states that do automatic restoration of rights as soon as someone is released. You have states that have, automatic voter registration policies that you have to opt out of voting. So it's like so many different things in terms of democracy expansion that are possible, both through, whether it's through, policy being passed at the state level or constitutional amendments being passed via the ballot, I think are real possibilities. So I don't want to dash anyone's hope on the ability to one day get to a place where we have a full-on expansive democracy that allows full-on access. One thing that I would say to your initial question around that is that judges are also people, right? Or people who are aspiring to be judges are also people, right? They're made up by their experiences. They're made up by their existence. You know, if you saw during the Kavanaugh hearings, a lot of the things that were unearthed was the fact that he lived such a homogenous existence as a human being, right? He basically only hung out with people of his ilk in his thing from the time he was a teenager all the way to adulthood, right? And so the challenge for someone who looks like me or someone who looks like you, Pam, is that, you know, if you have somebody whose whole life experience is only shaped by that which they've lived without having experienced diverse friendships or diverse relationships or understanding empathy and care, compassion for people, that is going to weigh in to them being biased as a member of the judiciary, even if they can somehow look at the notion of being fair and balanced, it's still going to tilt towards their life experience. And that is why we oftentimes argue the notion that needing more diversity on the bench is so super duper important. But I just want to stress to you in asking the questions, yes, they may not be able to give you their opinion on gun control or abortion, but they can, in fact, tell you how they've lived, where they've lived, how they've been brought up. You know, were they a member of the Peace Corps? You know, have they, you know what I'm saying, have they participated in their faith upbringing in a particular way that is illuminating for you? You know, what is their background? If you remember during the hearings for Justice Sotomayor, she talked about that and was oftentimes ridiculed by oftentimes older white men at this notion that growing up in New York as a Puerto Rican woman was somehow, you know, not conducive to being on the court, right? and she had to push back at that narrative that the idea that I grew up in this urban environment would somehow make me less impactful as a judge. Instead, she leaned into the fact that it made her more impactful because of the diversity of people, the diversity of experiences that she's had. So I would definitely stress that when you're at these judicial hearings or forums, when election season rolls around and you get a chance to ask the question, it may not be able to be as linear about, you know, what they're ruling on, but it can be more open as to what kind of person are they? You know, where does their humanity lie? And if there's absence of that, then you know not to support that kind of person.
One of the things that was interesting, of course, during the Trump administration was that the president at that time was very open about having litmus tests for selecting Supreme Court justices. He ran on that. Hey, I'm going to have a litmus test for this or that. And people seemed to think that that was great because he would select the people that they wanted. Having a litmus test is inherently dangerous, isn't it? Douglas, did you want to weigh in on this or was Sita?
I might weigh on it a little bit. I think that in his response, Judge Mahid raised and touched upon a very fundamental question that I think informs this whole discussion. What is it that we actually want? Do we want a judiciary and a Supreme Court that is going to be an impartial analyst of the laws? Or is what we're actually after a judiciary that is in line with our values as progressives? And, you know, as I kind of alluded to in my remarks earlier, on one level, you do want an impartial judiciary, right? You want the rule of law. You want laws to apply equally to everybody. You want somebody who's going to be a clear-eyed analyst of what the law actually says. At the same time, for instance, up until 1865, the passage of the 13th Amendment, a fair and impartial reading of the Constitution might tell you that slavery is fine. There's nothing in there that actually says that this is wrong, that this is not allowable. In fact, the Constitution implicitly recognizes slavery in certain places. So a fair judge might tell you, look, like as much as you might dislike slavery, you might think it's important, you're going to have to convince all of those slaveholders in the South to part with their property through ordinary legislation if you want to get rid of this. So on the one hand, you have to ask yourself, is that the kind of judiciary we want? Is that the kind of justice that we think is worth defending? within our federal system, within our American way of life. Like I think that there are, I think it's an inherently complex question. You know, I don't want to dismiss the view that impartial and independent judiciary is important, but I do think that all throughout legal thought, you do have this other question of, you know, what are the actual values that are the basis of free democratic society, and how can we bring, you know, our on the one hand, our obligation to be true to what the law actually says, in accordance with this other system of values that does not always prevail in the law, but that is the sort of the basis of why we think that, you know, democracy and liberalism are good in the first place. Like there are times in which things that we now take for granted as part and parcel of a free and good society, you know, the right to vote for everybody, including women and African Americans, you know, the right to marry, all kinds of things were not protected by the law in the way that they are now.
Lucina, a quick question for you. When you're sitting in front of a ballot and it's time to vote, where do you go as an individual? Where do you go to look up a judge? If you're going to make a decision about a judge, what resources do you use?
Oh, I don't know. I mean, I wind up just sort of following sources in the media that I follow up for all kinds of news. One thing I will say is that as far as the Supreme Court is concerned, I mean, people have talked a lot about state courts tonight, and they're very, very important. I will admit that I spend most of my time thinking about the federal judiciary and the federal Supreme Court. One of the things that makes the situation so difficult is that the actual mechanism for putting justices on the court, they're nominated by the president, confirmed by the Senate. That process in itself is one that excludes a large part of the country or sort of deprives a large part of the country of their right to an equal say in the process. I live in Maryland. Maryland is not a very sort of important state, mathematically speaking, when it comes to the composition of the Senate. Given population trends right now, by 2040, about a third of the population is going to control 70% of the seats in the Senate. It's already skewed right now, but the way that the Senate is designed, states that have smaller populations have much more of a say when it comes to judicial nominations, confirmations, than large populous states. And so, you know, while I would love to say that when I come to the ballot box, I have this expectation that part of my vote is going to be deciding who's going to sit on the Supreme Court if Democrats have the opportunity, that's not really the case. We have an electoral system that doesn't actually provide equal rights to every American, no matter where they live. And so that's one of the difficulties here. And one of the reasons why, as much as you'd like to think that the judiciary is impartial and something that treats everybody equally, even at the point of judicial selection, confirmation, there are these built-in inequities within the system that I would argue have to be rectified. But all this is a way of saying, I guess, that you know, there is this sort of civics textbook understanding of where our judiciary sits and how it's composed and what it's there for. And then there's reality, like there's SB 8 and that decision. Then there's the skew of the Senate. Then there's Shelby and the Brnovich decision. All of these ways in which we see the Supreme Court making decisions that are in line with a particular philosophy, in most cases, because most cases are not very ideological, they're like technical legal decisions. But in the cases that really matter the most in many ways, you do see, you know, a kind of steady and calcifying conservative majority. And it's a majority that's been created because people ask these questions on the right that we tell ourselves people aren't supposed to ask. Conservative will vet people who are nominated to the court on the basis of what they think about Roe versus Wade, what they think about religious freedom, to make sure that the people who are going to end up there eventually, from the time they're in law school, are thinking in a way that is in line with conservative ideology. That's what Federalist Society is for.
That is true. The Federalist Society has had a tremendous and outsized influence on the selection of Supreme Court justices. And by the way, Senator Bullard in the chat suggested a couple other alternatives, and that is the local bar association. And as he suggests, the local affinity bar association, such as the women's bar, the Hispanic bar. This is something, these are resources that someone who's trying to make a decision about voting at the local level for a judge could use. We have a couple of questions here waiting in line. Our first from Raed Al-Shaibi. Raed, you have the floor.
Well, thanks, Phil. I just before I ask the question, I really wanted to say that this was a powerful dialogue and presentation by four of our invitees today. I mean, Senator Bullard, Doug Keith, and Judge Majid, Al-Sita. I mean, the differences and the different weights on this subject is really clear. And this is what we need. It's, when you talk about this thing, it's not about emotion. I know emotion is involved, but it's important for all of us to know how when judges make decisions, they follow certain rules and bills get created, right? By politicians, and they vote on them, and they become laws. And here my question, and I'll bring this up. I think Senator Bullard, and I want to salute you for one of your votes, and it's a vote that you voted. You were the only one who voted against that bill. And I don't know if it's maybe it's appropriate to see how laws gets made. You voted against the BDS bill. You're the only one. And although it challenges our basic right to freedom of choice and expression, you were then bullied to change your vote. And so can you explain, and that became a law right now, So can you explain what happened and how can these laws become so intimidating to our freedom rights? Sorry if I put you on the spot on this.
No. Listen, it was my record, so I appreciate it. And yeah, so when I was in the legislature, just so folks know, there's literally less than 5 bills that really bothered me on votes, and that was one of them because of the fact that I was intimidated by both folks on the left and the right.
Can you explain what BDS stands for? What is this bill about?
So BDS stands for Boycott, Divestment, and Sanctions, and this is a protest movement created by Palestinian activists, within the West Bank and what we know as the State of Israel, to challenge the Israeli government to be better, be fair, be more equitable to the people who also live there that define themselves as Palestinians. And so this is very much, an international discussion that somehow bubbled up into the legislature. And so what the legislature was basically passing is that any company or entity that chose to, react to this notion of the boycott would be penalized by the state of Florida for, reacting to that boycott. And for me, it was very fundamental. And I think the judge might appreciate this. Boycott has already been supported as a right, a fundamental right of protest for Americans, and it's been codified by legal action for decades. The notion that we can, as a part of our First Amendment, create boycotts, activate boycotts, and do whatever as it relates to boycotting companies here at the U.S. level is something that is protected. And so I couldn't quite comprehend how we were, again, pursuing a bill that undermined a First Amendment protection for U.S. citizens, but being critical of companies that chose to participate in said boycott. What I found to be very hypocritical was that we would pass these bills to send up to Congress criticizing countries that act as terrorists. We would criticize countries that, would undermine the protections of folks. We criticize Cuba, criticize Syria, criticize the Sudan, but yet and still we were willing to kind of like pursue this notion that one country in particular, that people had a particular, have particular opinions about, was somehow could not be boycotted or could not be protested by people who lived within that region, was a little alarming. And so that's really what it boiled down to.
Can I just throw one thing? I think the notion here from the other side is the boycotting of the product that are made in illegal settlements or in occupied territory. I mean, if you're allowed to do trade with Israel if the product was made in Israel, but if the product is made in occupied territory, you're allowed to boycott those, and that's the bill. This is clear, more defined, I think.
Yeah. So yeah, I mean, it became, I think, unnecessarily controversial. That was just my opinion. My opinion was the idea of undermining boycotts just didn't make sense. If the shoe was on the other foot, we wouldn't stand for it. We'd be yelling from the rafters, protect the First Amendment. But somehow we made the allowance going the other way. So it just didn't make sense to me.
So how the judges do react? So if I'm standing in front of a judge, how do I get fair treatment? Can I challenge this law?
Yeah, I mean, I think as that law stands, I think it's unconstitutional on its face, and other companies have found ways to push back against it. I mean, there was some criticism of Airbnb. There's been criticism of Ben and Jerry's because they have been a supporter of BDS. So other companies have found a way to circumvent the problem. You're still able to find Ben and Jerry's on the shelves at Publix.
Would any of our other panelists like to weigh in on this? So we have just a few minutes left.
I want to not weigh in on that subject, but maybe raise another topic
Sure.
But I don't want to move off this topic if somebody else wants to make a comment on it. I'll
just say quickly that several judges have struck down anti-BDS laws in Georgia and Arkansas and other states. So to the extent judges have weighed in, they have been hostile to these bills.
Okay, we've talked a lot about the judiciary and whether it's fair and impartial or leans one way politically or not. But I think when we analyze the judiciary, we would be in error if we did not think about our economic process. Almost every significant judicial opinion has some element of economics in it. So we live in a capitalist society, and it goes without saying that the person with greater wealth purchases greater luxury. And so the question must be asked, I think it's a fair question, subject to debate. If you are wealthy, are you then able to purchase a better quality of justice? Is justice itself subject to quality and subject to capitalist society? For example, is an O.J. Simpson defense available to everyone? And so the issue for us as politicians, or not for us, but for politicians, to say when you come before the judge, if you are a wealthy person and if you are not a wealthy person, is the quality of justice trained consistent with the person's ability to afford it? Is there such a thing as the wealthy affording a better quality of justice? That's something I don't have the answer to, but I think that's a critical analysis, because if the economics, we live in a capitalist society, and if you buy a better quality, if you have more money, a better quality of everything, you can drive a Mercedes or you can drive a lower quality. I don't want to name any quality car, but a lower quality car, and you can buy a shirt at Burdines or you can buy a shirt at Kmart. It's up to you.
Well, and Judge, one of the things I'd have to mention is that we had an event. We had a First Thursday event called Bias on the Bench, where we looked at the issue of specifically within the state of Florida, but a statistical analysis of rulings within the state of Florida and how very clearly people of color and people with less money were spending longer periods of time in prison for a given set of offenses than people with more money and people that are white. And those numbers are glaring. They literally like a bright horn honking. And by the way, before we go too deep off on this subject, this could probably be yet another event. And we did cover this extensively on our Bias on the Bench event. Okay. I know we have at least one more question. I'd certainly love to get to her before we're running out of time. May I go very quickly to Bonnie Ida? Bonnie, I know you've had your hand up for some time. Please give us your question and maybe we can come back to this.
I hope it's not too long. It's about impartiality and bias. And the question is, Judge Majid spoke about the 6-week law in Texas and said that it was the court impartially let it go. And since it is such a disturbing law, and what I understand is this happened through something called the dark docket, something like that. So I wonder if someone can explain what that means and why it was able to pass without really discussing a really deep analysis of it.
It's called the shadow docket.
Shadow docket. Okay, thank you.
Any of our panelists like to pick that one up?
I think Osita might be the best qualified to discuss the shadow docket.
Oh, well, I mean, as far as I understand, the shadow docket is basically supposed to be an emergency mechanism that allows the court to sort of quickly adjudicate certain things without offering much of an explanation about why it's doing. That's the simple rendering. Maybe Douglas could offer a more technical and accurate rendering than that. I can say a little bit about the SB 8 itself and why it was so remarkable. So I'm sure everybody knows, conservatives have been working for a very long time on the abortion issue. They're hoping to see Roe v. Wade fully overturned. That might happen actually in another case this term. But what Republicans did in Texas was they constructed a law that was a 6-week abortion ban. The real hitch in it, though, was that the state of Texas was not actually going to enforce the law itself. That would have been flagrantly, in violation of established precedent. What they did instead was said, okay, look, we're going to have private citizens able to sue people who abet abortions in the state of Texas for $10,000 at least. And that's a way of saying, well, we've passed this law that's aimed at curbing abortions, but we're not actually the ones who are enforcing it, because that would be against court precedent. We're going to have the private citizens go out and do that themselves. John Roberts, in his alignment with the liberals, even he called this an unprecedented decision. The idea that you could have something that might be facially unconstitutional or against precedent if the state did it, but it's okay because we're going to create this mechanism where private citizens act as bounty hunters to enforce the law themselves, so the state gets out of it. That's a whole new kind of construction, and one that raises a lot of deep questions. Is this the means by which states can, not only construct their own facial unconstitutional abortion laws, but sort of contravene existing court precedent and the Constitution in other areas? Is it as easy as states saying this is unconstitutional, but it's not really if we let the private citizens actually take care of enforcing this law? That's a new area that the court hasn't really had much experience in.
Please forgive me for interrupting you, but I know that Douglas, did you want to weigh in on this very quickly? We have about 30 seconds.
No, I like Osita's responses. I'm happy for him to keep going.
Why does the shadow docket allow that? Why could they invoke that particular method of allowing this to happen?
30 seconds.
So I'll say that Osita's description of the shadow docket, I think, is spot on. It's essentially a mechanism by which the court deals with emergency requests for it to give its say on a case. As a result, it does so without hearing the case, without issuing a full opinion. And often it's doing so in a sort of temporary status. So this case, for example, is very likely to come back to the U.S. Supreme Court later on. This was not the court's last say on this law, if anyone had to bet. But that does not mean that sort of it was right of them to dispose of it in this way. Everything Osita is saying about the sort of unique and bizarre approach that the legislators have taken to this law, essentially outsourcing enforcement of the law just so they couldn't get in trouble with the courts, gave the Supreme Court ample reason to step in and say, while this case is moving forward, we are going to enjoin this law. We're going to stop it from being enforced because we think there are enough problems here that we are concerned. So there was, even though it took place on the shadow docket and the court didn't provide sufficient or a lot of reasoning, they still had ample opportunity to stop the law based on all of the problems that Osita is speaking about.
And that essentially,
I think relevant to that, Mexico's court has just ruled that you cannot criminalize personal choice. And so instead of seeing people from Mexico coming across to Texas, I think we're going to see a lot of people from Texas going to Mexico.
that is exactly the truth. It is a very, very interesting time in so many ways, and we were so lucky to be able to have this discussion tonight. I am so sorry. I know there are some folks that probably have more questions, but we're essentially out of time. I'm going to ask all of you on Zoom to come off of mute. You can bring yourself off of mute. In just a moment, I'm going to ask you to give our speakers a round of applause. But as we wind up tonight, I want to quickly go person by person among the four speakers, if you can, just very quickly. I have just a few seconds. Can you give us an action item? And Judge Majid, since you were speaking, could you quickly give us a quick action item? I know you've already suggested that all those that are Democrats get registered.
I don't know what I just said. We cannot continue having not a single say in all the constitutional officers that are elected in the 18th Judicial Circuit.
What?
Fair enough. And Senator Bullard, an action item.
Yeah, every year there's going to be a judicial election. Don't be afraid to speak up and ask questions. We have a saying in the community that closed mouths don't get fed. So make sure you're opening your mouth to ask the important questions about who these folks are, what they're about, and whether or not you should support them as judges.
And Douglas Keith, your action item.
I love that. For the judges that are appointed rather than elected, I would say find out sort of what courts are in your area, sort of who has you in their jurisdiction. And then if there are openings and people are going to get appointed, make some noise around those appointments. Make sure that the people in power know that you're watching and you're going to hold them accountable if they appoint people that you don't want to the court.
Osita Nwanovu, do you have an action item for us?
Yeah, as far as the federal courts are concerned, the Supreme Court is concerned, I'd say call Congress. Unfortunately, down in Florida, you don't have two Democratic senators. But look, call somebody else a senator. Call Dianne Feinstein and you know, anybody else who's on the fence on an issue on the filibuster or court reform. Call them and say, look, I live in Florida, but these are issues that affect us all at the federal level. And we need to have a court that is reliably protective of democratic rights, certainly. And if you're progressive, we need a court that's going to stand up for us on, you know, labor issues, on climate issues, on the progressive agenda. I think that's what you need to do. Call members of Congress, maybe not necessarily in Florida, but people who are going to be critical in deciding this issue within the Democratic caucus.
Excellent action items to all of you. And I would like to remind our audience, if we don't take action, if you walk away from this event tonight and do nothing, then we have failed. This event tonight is really, all of our events are to encourage you to make a change in the world, to make the world a better place, to step forward and do something positive. Because if we fail to do that, then what's the point? The fact that we were here together tonight, please spread the word, share what you've seen tonight with other people, bring them to the website or to our Facebook page to see a replay of tonight's event. So please, take some action as a result of this evening's event, because there's no point in learning if you're not going to share it. Again, our next meeting will be October 7th with an examination of human trafficking, one of our nation's great shames. It's a problem around the world and right here in our own community. As you can see up on the screen here, human trafficking, it's all around us. This is not something in just a faraway place. So for everyone, please, if you're with us on Zoom, you're off of mute, and let's all give them a round of applause, please, for our wonderful speakers.
It's a pleasure
Thank you very much.
It's a pleasure
Senator-
serving you wonderful folks.
Thank you so much.
Senator Bullard, Douglas Keith, Judge Majid, Osita Wanavu, we are so honored and so privileged to have you with us tonight. For all of our guests, for everybody that is following us on Zoom and on Facebook, we thank you. Please go to our website, www.scpa.com, and check us out. We thank all of you tonight. We look forward to seeing you in the future. And for the Action Project Committee, we ask you to stay on the Zoom because we'd like to do a little discussion afterward. But for everyone else, have a beautiful evening. Thank you so much for being with us, and a happy and healthy weekend. Good night.
Bye-bye. God bless you.
Good night.